Hello, everybody. How are we doing? Yeah, a couple more sessions to go before the end of the day. Welcome to this session. We have William Richard-Coggan. Will is a director of top 50 law firm called Freeths LLP. He works with a lot of early stage startups, enterprises, multinationals, you name it, all kind of companies, guiding them through the data protection regulation landscape. Very important, and I guess that's why you're all here. We did ask him to explain his talk badly beforehand, this is how it went. A great talk, but I cannot tell you because of hashtag GDPR. But luckily, we are here, and Will is here, and Will is a lawyer, so we can navigate around the GDPR. Maybe you can tell us about this. So Will is going to give us an insider's perspective on ways that privacy compliance can be used as a competitive advantage. We all want competitive advantage. So I never thought privacy compliance can give us that, so that's great. And he will present some case studies and anecdotes on the things that he's seen in the past and illuminate a journey into the depth of modern data protection. So please give a warm welcome to Will.
Thanks very much. Hopefully you can all hear me okay on the lapel mic. I like to sort of move around. I'm going to leave some time at the end for questions, but if anyone wants to sort of stick their hands up and ask as we go along, that's okay as well. I'm a lawyer. You can tell that from the fact that I'm wearing a suit and a tie, which makes me slightly unusual in this audience. But I thought, I may as well look the part because in a lot of ways, what I'm going to be trying to persuade you is that your perceptions about lawyers and the sort of legal approach around privacy and data protection, a lot of your assumptions are probably wrong. And that a lot of the challenges that people see in this area, a lot of the difficulties that they encounter are born more out of that sort of false perception and worry about this area, which was promoted last year by a lot of people using a whole raft of sort of scare marketing tactics. We heard an awful lot about, massive fines coming down, and a lot of things about, data protection being the reason that people can't do things. And that has led to an approach or a sort of mindset around data protection that is regarded as a challenge, as a hurdle to be overcome. And what I want to do is to talk about the way in which sort of the conception of that has matured over the last couple of years, using case studies of encounters with some of my clients, but using as the sort of basis for it the 7 stages of grief, which, let's face it, GDPR for a lot of people has been seen as giving them a lot of grief. But taking that and looking at, moving in an increasing maturity pathway from denial that there's a problem at all through to acceptance. So where to start? I started, I've been working in data protection for sort of 10, 15 years, long before the GDPR came out. I feel, in a sense, that I'm a bit of a data protection nerd, a hipster. I liked data protection before it was cool. And now everyone's talking about it, and their latest album was much more mainstream. But when I started really getting into GDPR and I started going around and talking to clients about it, I encountered a lot of denial. A lot of people whose instinctive reaction was, this isn't a problem for me. I don't want to take this on. And all of these are quotes from genuine clients, and no, I'm not going to name and shame them, but including people who were saying, we don't process personal data. GDPR, privacy, these are not concerns for us. Now, every business processes personal data. Personal data is any data that is about an identifiable individual, that tells you about their activities, that tells you something that allows you to identify them. So if you've got one member of staff, you're processing personal data because you've got payroll information, you've got information about what emails they've sent and received. But for most people, they're dealing with a whole raft of other things as well. They're collecting data about customers. They're wanting to use mailing lists to send out information about their products and services. This particular business, they were working in medtech. They were part of the NHS supply chain, and they were doing testing, including pathology. And so they were collecting information which included blood samples. They had already signed an agreement with the NHS trust that they were primarily working for, which warranted that they were fully GDPR compliant before they came and spoke to me. And they said they were relaxed about that because we don't process personal data. And that was so wrong on so many levels, as you might imagine. But it was a real difficult process to try and persuade them, having called me in, having recognised, that they needed advice, that actually, there was stuff here that they were going to have to engage with. That when they were getting records through, when they were getting samples through for testing, there were obligations that they were subject to around how they collected that data and held it and maintained it and stored it and in the end disposed of it. And that mentality that this was something that had been created led to something I heard repeated times from people. This is just the next millennium bug. This is just the next sort of problem that people have invented to try and generate fees. Now, I was relatively young when the millennium bug was a thing, but I know that there were genuine technology problems that came along with it, and there were solutions. The reason it didn't cause a massive problem was because people actually got to grips with it in the areas where it genuinely impacted on them, and they'd put in place those solutions ahead of time. With GDPR, that didn't really happen. So what happened instead was that a lot of people last year put their head in the sand. They decided that they weren't going to engage with privacy. They weren't going to think about these challenges. And then down the line, they started to see enforcement action being taken. They started to see companies being sued. They started to see companies getting fines levied against them, and that perception change. And that's really, stage two. When you move past the denial and into the pain. And the pain sort of manifests itself in all sorts of different ways. But one of the ones, again, that beset quite a lot of my clients was that they engaged with consultants who didn't really know what they were talking about. This was one of these areas where everyone wanted to jump on the bandwagon, and there were a lot of people going out and giving very superficial, bad advice about all the things that you could no longer do because of GDPR. And one of the classics, people going around and having to delete a whole range of their marketing information. Wetherspoons deleted the whole of its database of marketing contact information and started building it from scratch because they perceived the challenge of complying with GDPR to be too onerous. That probably says more about the way in which they were collecting data before than it does about anything else. But I mean, it caught a lot of headlines, and a lot of other people followed suit. But it's created a massive cost for a lot of businesses. They've had to go out and re-engage. They've lost an audience, which they're now having to rebuild at considerable expense. And it wasn't necessary. It derived from a sort of misunderstanding. But equally, there's a more useful sort of pain that businesses are going through now, and that is that they're starting to feel a real impact from a growing public awareness about privacy, and a sense among consumers that a business that doesn't care about their privacy is probably not a business that they can trust or engage with. Now, that's not always, that's not true for every business, but it is true, particularly in areas like retail. It's true in areas like professional services, where you see a lot of direct engagement with consumers. And you're starting to see consumers waking up to the need to actually have answers to, well, how are you respecting my data? What are you doing with it? Driven by companies like Apple, who've actually sort of jumped on this bandwagon quite quickly and who have made privacy a virtue in the sort of consumer offering that they put out through the iPhone, through the sort of cardless payment options and things like that. But that, you know, that the pain hasn't really started to hit home in the way that I think it will if we start to see sort of large-scale consumer desertions. Facebook, for all of the privacy controversy that it's been suffering from, has only lost about a percentage of its market share in Europe over the last sort of 18 months, whereas the predictions were that GDPR would have a much more significant impact. You know, that percentage probably has as much to do with changing demographics and a younger audience actually not really wanting to be on Facebook as their platform of choice, because you're still seeing a growth in the Facebook-powered Instagram platform, for example. So it's not a desertion that's based around a mistrust of Facebook to handle their data, despite, you know, a decent amount of evidence that, that, you know, there are things that they haven't got right. People who understand that much instinctively then want to know, all right, so I've got to do something. What's the least I can do? So the next sort of conversation that I started to have with people who'd seen which way the wind was blowing, people who wanted to at least look like they were compliant, was to turn around and sort of say, well, okay, now what do I have to do to get an audience to believe that I'm taking their data seriously? Now, that's a slightly uncomfortable conversation for me to have with them because, you know, as a lawyer, there's always going to be a decent amount of stuff that I'm going to have to say, look, guys, you know, you have to do all of this at the back end before you can have something that is genuinely compliant or looks it. It would be a little bit like, from a sort of software point of view, simply changing the user interface and expecting there to be a change in the, or expecting people to accept that meant that there had been a change in the underlying product, which of course never happens. But this particular challenge, again, you know, has been really sort of endemic. You know, I spend a certain amount of my time working with startups, you know, with small businesses, often really just sort of like coffee and a chat, you know, trying to help them to sort of steer in the right direction, trying to sort of give them a sense of the big pitfalls that they have to navigate. And a lot of those conversations start with, oh, well, I just want a privacy notice. You know, I just want something that I can put on my website so that people can find it and they can know that I'm compliant. But the problem with that is that a privacy notice is a manifestation of an obligation under GDPR around transparency. So the whole point of having that notice is that you're giving disclosure about what data you're collecting and how you're collecting it and how you're handling it and what you're then sort of going to do with it, who you might share it with, how you're going to safeguard it. So to fill out even that one document, you need to have a proper understanding of, you know, what is your business, what data is your business collecting? Why does it need it? What are the purposes in law for processing that? And so actually, often the privacy notice, which is the most visible, the most sort of public-facing part of compliance, that's at the end of the process. Very, very hard to do that at the beginning, because at the beginning, you don't know the answers to any of those questions. And so, again, you know, what we see is a lot of businesses who will just go and they'll find another competitor who they think probably is doing the same sort of thing as them and who seems to have an up-to-date privacy notice, and they'll just copy and they'll paste it and they'll put it on their own website, and if they think about it, they'll change the name. Well, you laugh, but you remember that issue about the ferry company that was providing non-existent ferries as part of the government's Brexit readiness programme. They were using terms and conditions from a pizza company, and they hadn't changed all of the details. So they were all in their terms and conditions. They had stuff about, you know, I will make sure that it's delivered in half an hour or you get your money back, which when you're talking about, you know, trans-channel ferry logistics, it's quite an expensive commitment to be making, I would have thought. But, you know, those sort of things that approach, lands you in all sorts of potential difficulties. And the problem is also, who do you trust? So one of the areas where there's been quite a lot of, again, visible change around data protection has been cookie implementation. We talked about this a little bit in the panel session that I was in this morning. The need to be able to compliantly place tracking and cookies and things when you get a visitor to your website. And people casting around for an approach that they could follow that would mean that they were compliant went and looked at the website of the Information Commissioner's Office. So this is the regulator that oversees compliance with data protection law in the UK. And so it was a little bit embarrassing earlier this year when the ICO had to admit that actually they had got their approach to cookie notifications completely wrong, and that everyone who had been following their approach was also getting it completely wrong and needed to change it. And they admitted this because someone reading the guidance published on their website noted and commented to them that that guidance recommended an approach which was diametrically opposite to the approach that they themselves were taking. And they're not alone. A couple of months ago, one of the first cases around how you get cookie notifications right under GDPR was published by the European Court of Justice. It's a decision called Planet 49, which if you work in that area, you might have heard of. But it was published on a website which placed cookies without any notification at all. So the CJEU's own website was non-compliant with the judgment that they were publishing on it. So this is the sort of thing that's got wrong a lot more often than it's got right. But even these very superficial things are a challenge. And when I'm asked by a client to work with them, the first things that I will do is go on their website and look at, what tracking are you placing, what cookies are you requiring at the outset, how are you handling notification, what's your privacy notice? Because that gives me a sense of how credible that business is, how well they've understood their basic obligations. If they're getting that right, they might still be getting a lot of other things wrong. But if they're getting that wrong, almost certainly everything else will follow, and generally that's sort of been borne out. But this is the point at which things start to get a bit more positive. If I can, get the connection to work on my clicker. Because once you get past that point in the conversation, suddenly people start to think about, okay, I can see the scale of the challenge, and I understand it, and I'm going to engage with it. So, stage 4, which is the sort of midway point in that pathway, is a process of reflection. So I was doing some work for a client that was a sort of automobile dealership, and they started off with a very narrow instruction. They were buying a new database to handle CMS. The way in which they were going to do their sort of contact management for all of their customers, they were a franchise setup. So they were going to be drawing data from a number of different sort of franchisees, pooling it and then passing it back out, but in a way that involved only sharing data with the right sort of parts of the franchise. And so they'd recognised, there was an issue there. We were looking at the contract for them, but we started to talk about, their wider compliance. We started to talk about the fact that the principles that we were sharing with them, were things that applied equally to the data they held about their staff. And then it emerged, well, actually, their ultimate parent company was based in Japan. And they were sharing all of their data with Japan, which is a big no-no around transfers of data overseas when it's personal data. Japan actually, since then, has had an adequacy decision, so it's a safe haven for data you can share now. But at the time, that wasn't the case. We started to see that there was a lot of data that they were collecting that was unnecessary. So one of the key concepts that we sort of work with clients to understand is around embedding an approach to privacy at the design stage. They for historical reasons, when they signed up a new member of staff, they would put them into a database and they would collect information about them, including national insurance number, about sort of home address details, date of birth, all sorts of other things, which from time to time, particular elements of the business were needing. But that was going into a record that was being shared with everyone, including a unit in the business based by their headquarters in the Far East, whose only function was to issue that person with an email address on the system. And yet they were getting, the national insurance number and the date of birth and all of this other thing. And that, once people start to understand that and they start to sort of drill down into it, now sure, it can get quite intimidating. You start to sort of see problems everywhere and see challenges everywhere. But as you start to sort of see the shape of it, you also start to see, where solutions might come through. And that in turn then leads to a sense of potential optimism, particularly because so many people are getting this wrong. And I sort of touched on this already, but increasingly now I'm starting to have conversations with clients who say, I want to get this right, not because I'll be breaking the law if I don't, not because I have to be able to sign off on warranties to people that I'm a supplier for, although all of that is true, but actually because I think now I can mark myself out. I can stand out from the crowd of other providers by demonstrating that I take privacy seriously, that I actually adopt it at the core of what I'm doing. This client is a US-based cloud service provider in the telecoms industry. And they are offering a service that is relatively straightforward to replicate. And they're in a relatively saturated market. They would say that they do things, distinctively in a range of ways, and I'm sure that's true, but I'm sure also that a lot of their competitors would also say that. But one of the things that they are doing is to actually work to make sure that their approach is genuinely, substantively GDPR compliant, making sure that they never collect data that they're not going to need, making sure that they never hold on to data for longer than they need it, and actually educating staff from the senior management right down to the people who are on the reception desks and particularly the salespeople about the principles and the sort of core concepts around data protection that are required. And what's been very interesting is that they have had a sort of almost road to Damascus-like experience where now they're going out and being sort of advocates for this approach and for this technology. But they are engaging with customers who they are in turn having to educate. They're going out and they're sort of saying to their customers, this is what we're doing and this is why it's important that we're doing it. And their customers are then sort of saying, well, okay, yes, so we can, if we use your product, we can now say to the consumers, so their customers are hotel chains or travel or retail sort of businesses. They can actually say to their consumer customers, we're using a platform that takes privacy seriously so that we can protect your privacy. And they're seeing value in that, and they're seeing, they're driving sales through that as a particular way, without having to worry about price, without having to worry about so much about, being able to answer questions about infrastructure. There's a lot of things which are fairly standard across the industry in terms of uptime, the sort of SLA commitments that they're making. But their point of distinction is, we're going to help you to be more privacy compliant for your customers, and the customers are taking that on board and actually, making buying decisions based around that. the ideal is that I have the conversation with these people when they are at the sort of drawing board stage, you know, when they're sketching out the first design of their application. That is great because they can start to embed the design concepts, they can start to design around the sort of legal framework that requires only to capture the data that's necessary, only to retain for as long as necessary, to ensure that the database that they're using to store the information they're capturing is one that can be easily interrogated in order to provide data subject access, which is a requirement where any individual data subject has to be able to get hold of a copy of all of the data that you hold about them on, you know, across your whole system. And, you know, that's great, but of course that's not always the way that it works. So quite often I'll be having a conversation with businesses that are a lot further along the pathway. You know, they'll have a product either that is already live, or they'll have something which is a long way into development. This client, working as you might expect from that photo in facial recognition technology, had already got quite a long way with developing the algorithms, the back end, you know, the agent that was going to do the analysis of the facial images that they were capturing, and they're operating in sort of commercial facial recognition, so not law enforcement, which is at the moment had quite a lot of negative press, but commercial applications in the private sector. And they were going out and they were sort of marketing to clients, and they were getting a lot of questions about the privacy compliance aspects of this, because it is an area that's somewhat controversial, and it is an area that people have sort of concerns about the way in which data is collected and used. And so we sat down and we sort of talked about the things that they're doing, and a lot of the things they were doing right, but there were a few things that we identified where data was being held longer than it needed to be. You know, and it was sort of being held in case it might one day be necessary. Or data was being held in a way that allowed identification when all it was needed for was training the next iteration of the AI, and actually it could do that in an anonymized way. And so we sort of actually talked about all of that, and I was really pleased because the reaction at the end of that conversation was not to say, oh, well, that makes my life much more difficult, but was actually say, right, you know, let's sit down, let's work through this, let's unpick some of the work we've already done, but let's actually sort of work together to try and make sure that we rebuild it in a way that is more compliant, that ticks a lot of these boxes. And again, you know, the driver for that is not compliance for compliance's sake. You know, it's not just to keep the legal team happy inside the company. It's because they know from the conversations that they're already having with their potential customers that these are the questions they have to be able to answer before they're going to get anywhere near a live deployment. And helping them and being able to sort of have conversations with them about, you know, what their clients and their customers' expectations are, and how we can meet those, is you know, it's a really positive way to actually sort of see these changes coming through and strengthening their commercial position and their business. And it manifests itself in very strange ways. You know, we as much as we do a fair amount of writing of the sort of formal legal contracts and things, we're also writing user guides, you know, helping the clients to actually design, you know, the guidance for their customers about this is how you use the technology. These are the things that you should make sure you never do. Because once that technology is out there, you have to sort of trust that it can be used in an appropriate way and in a way that's not going to fall foul. Because if there is a problem, you know, if one of your customers does misuse it, it's going to come back to you as the developer, as the vendor of that platform, if you've enabled them to use it in a way that gets them into trouble. Now, there's one point that I just want to sort of talk about at this stage because it's sort of central to the challenge that a lot of people face when they're working with the more cutting edge sort of technology applications that involve big data, which is where quite a lot of my work is. And that's something called a data protection impact assessment. So the data protection impact assessment is a formal requirement under law if you're doing certain categories of data processing. Anything that involves sort of bulk processing of data, anything that involves algorithmic decision making, anything that involves decisions about individuals which have an impact on them in a significant way. So almost anything in the healthcare sector, for example. You know, all of these, you're required to do a data protection impact assessment. A little while ago, the land developer of some private land outside King's Cross got into quite a lot of trouble because they were running a facial recognition pilot scheme in the public walkways. And I use public in the loose sense because it was technically speaking private land. But if you came out of King's Cross Station, there was no marker, there was no, apart from some quite small signs, nothing to tell you that you were walking from a public space into a private space. It was an open courtyard, and it had some tall lampposts, and on some of those lampposts it had cameras. And those cameras were not just doing CCTV, they were doing facial. And when that became known publicly, there was a fairly serious backlash against it. And a lot of privacy campaigners started to say, we want to see the data protection impact assessment that you have done as an organization before deploying this technology. And the answer that they got was, oh, okay, we'll stop using the technology. Which sort of sent a signal, and I'm being quite careful how I say this, but it sort of sent a signal that probably there wasn't an impact assessment there at all. Now, to take another example, and this is in the law enforcement application of facial recognition, there's recently been the first court decision on a case about the lawfulness of facial recognition under GDPR. And that was a case relating to an individual called Bridges who sued South Wales Police. South Wales Police were running, again, a pilot scheme outside rugby matches and in public spaces during busy times, in which they were using the facial recognition technology to detect and identify passers-by who were on a watch list, the watch list being arrestable individuals. People for whom there was an outstanding warrant but who hadn't been arrested, or people who might need surveillance because they were suspected of being interested in the commission of terrorist activities. So, you know, relatively serious purposes. But nevertheless, the way in which they were going about doing that was the wholesale capture of the faces, biometric information, about every single passerby, the vast majority of whom were innocent, at least as far as the police were concerned. And the challenge was, well, Mr. Bridges said, I'm one of these people who wasn't on the watch list, but my data was still captured, it was still processed by your system, and I didn't agree to that, and I'm not comfortable with it. And I think it's an infringement of my privacy. And the court looked at that, and one of the key questions that they had to consider was this question of an impact assessment. And they said that, in fact, South Wales Police had done an adequate impact assessment. What was interesting was that they, at the same time, in the same judgment, they concluded that South Wales Police had fundamentally misunderstood what counted as personal data when they set up their system, when they did that impact assessment. There was a whole category of information that they were collecting from the people who were innocent, from the people whose information was captured, compared biometrically, and then discarded in, it has to be said, a fraction of a second, but it was still going through the system. South Wales Police had taken the approach, none of that is personal data. And they drafted their impact assessment on that assumption. The court said, no, you're wrong. Even if you're only capturing it for that very minimal period of time, each of those records is distinctive of an individual. You might not know their name or their email address or anything else about them, but you can individuate them. In fact, you have to, because the way your tool works is it holds each record up and compares it to the biometric watch list and then discards it. And if you couldn't individuate, you couldn't do that comparison process. So they said, A, you've fundamentally misunderstood that, but B, you've done an appropriate data protection impact assessment based on your flawed understanding, and you've done it well enough and rigorously enough that we are confident that now that you know you got that wrong, you'll go back and do another one and you'll get that right. And so this is, again, an illustration of when you sort of embrace compliance, doing it in a meaningful way, actually adopting it wholeheartedly, even if you end up with the wrong outcome, even if you get stuff wrong along the way, almost that insulates you and gives you safety and an ability to proceed. That avoiding the problem, burying your head in the sand, just doesn't do. And so now, we come to the final stage, acceptance, the end point, and really the point that I'm sort of working towards in sort of going around and giving talks like this and engaging with the tech community, is really trying to get people to a point where they say, we're actually going to build with this stuff in from the ground up. We're not going to see it as a problem. We're going to see it as just one of the design parameters that we have to work within. We're going to recognize that there's a supportive ecosystem of advisors and consultants out there who can help with that. We're going to recognize that actually there's a lot of stuff that with a little bit of education we can do ourselves without having to go externally for support. But that we can build in a way that protects our users, that gives us a commercial advantage, and that actually sort of lets us stand out from the pack. And this, the image is a logo from a website of a client of mine who did exactly that. They started from the get-go. They worked with me from the very earliest design stage. They redid elements of their work. This is a company actually relatively local to here called Landstack, and they're developing a land use platform. So letting people do research about land that can be used, and all of the data sources that they're drawing into this are public domain. So it's planning information from local authority websites, and it's land registry records about ownership of land, and it's information about floodplain data and all sorts of other things. But building a picture of land use and ownership that has embedded in it at lots of different levels all sorts of personal data. But the way in which they're doing it, the way in which they're safeguarding it, and the way in which they then communicate that use to people means that they're very confident that they're getting it all right, and they're able to say to customers of theirs, we've solved this problem that you've been concerned about. And customers are saying to them, actually, this is something we've wanted to do, and we could never see a way to do it without falling foul of the data protection type constraints. So, that for them has been the difference completely, the difference between having a product that they can go to market with and not having a product at all. They very kindly sort of said that the work that we did together played a really significant part in that. So I hope, it's been a bit of a whistle stop. I hope it's been interesting and valuable, but I have tried to leave some time so that if people have questions really on anything data protection related, but any sort of challenges that you're facing, please do ask. And thank you very much for listening.
Well, thanks, Will. That was eye-opening. I know for a fact that next time I make a website, I'll make sure the cookies are stored correctly.
Yeah.
I don't want people at the next conference laughing at my website. So yeah, we'll do that. Does anybody have a question for Will? Yep, here we are.
Hi, Will. Thank
Hi.
you. Just really interested in, like, you see in the council towns now, people walking around with body cams on, and
Yeah.
all of the video data footage that they're capturing. So how do we go about finding out what data they've captured of us?
Yeah, so that's interesting. I sort of drew the distinction earlier about the difference between sort of commercial applications of this technology and law enforcement, because there are certain sort of exemptions that the police have around sort of use and capture of data, although there are also some special requirements that they're subject to. But the same thing is true of the police or law enforcement or a security company using body cams, as is true of Facebook and the data that it's capturing about you when you visit their websites, or Google when you're existing within their ecosystem. You can make a request. Under the GDPR, the ability to do that's been streamlined and simplified. You can go and you make a subject access request, and that can be done very informally. You simply sort of write to them and you say, I want all the data you hold about me. And they've got 30 days to comply with that. One of the things from a design point of view that's really important about that is it means you have to be able to identify all of the records you hold about an individual, draw them together and provide them in a really cost-effective way. And that's because some organisations are already finding that ability to make cheap, there's no cost for the data subject. The ability to make those sort of requests is being weaponised. It's being used as a tool to try and hurt businesses. So I think it's Blizzard Games that had that they got involved in the dispute around the sort of Hong Kong pro-democracy movement, and they censured one of their competitors in an esports event because they'd made some pro-democracy comments. And on Reddit, a campaign started where individuals were being encouraged to go, and if they were based within Europe, to make DSARs, so subject access requests, all at the same time to Blizzard. Now, the amount of information that each individual might hold is fairly negligible, but if you're getting thousands or tens of thousands of these requests, and you don't have the infrastructure in place to draw that data through and deliver it quickly and cost effectively, it can be very, very expensive. But you ought to get a lot of that data if you want it. And there are some interesting tools just to get an insight into the sort of thing that is out there about you. Both Google and Facebook have very easy tools to use to request the complete data set. I don't recommend doing it unless you've got quite a lot of time to set aside and read it, but it's quite eye-opening, the level of insight they have into you. And you can be left puzzling exactly how they got some of the information that they seem to have about your habits and interests and spending preferences and things like that. Yeah.
Hi, Will. Thank you for the talk. Obviously, you've spoken about how you've assisted businesses in achieving their GDPR compliance, but as a consultancy business, we often find that it's difficult to say what good privacy looks like. Like, obviously, there is a minimum and a base standard, but what good privacy actually looks like isn't the problem that we don't as yet have the e-privacy regulation in and a standard such as the certifications under GDPR as yet. So at the moment, it's almost like a shot in the dark. You can obviously do the minimum required, but you don't have an idea as to what privacy by design, data protection by default looks like until those standards actually come out. I mean, you get ISO and the rest of it, but it's not necessarily specific to personal data.
Yeah, I agree that that's a challenge. There's sort of two answers to that. One is that there are some design standards out there about privacy by design more generally. So not particularly focused on GDPR, they predate it. So Anne Kavukian and had sort of 7 privacy by design principles. And if you work towards those, you're a long way there. The other thing is, I suppose, If you start from an approach of total transparency, and you stop yourself every time you're about to do something that you think, actually, I don't quite know how I'm going to explain this to my user, you're not going to go far wrong. Because actually that's a really good litmus test, understanding how is an end user going to feel about this. As soon as the temptation or the instinct is to try and mask or bury, activity that you're doing, it probably means you're stepping off, a track because you're moving away from their expectations. Now, there will be things that people are resistant to. This client, the last one I mentioned, who really went all in with this idea of building something that was sort of private from the ground up. When we wanted to assess impact, we actually went out and we constructed a poll, and we did polling. We went out and they ran an online sample of 1,000, 1,500 respondents to understand what their expectations were about how their data might be used, and how that expectation changed depending on the level of education they had about privacy issues. And that was really good because it meant that we could understand if there were things that were indispensable to the product, what are we going to have to explain at the point of getting their agreement or at the point of communicating to them about what we're using in order to move their attitude to that from concern to acceptance. And so there's a lot of things like that around, but you're absolutely right. There is no codified good practice, and there's so much bad practice out there that it's often quite difficult. So what I'm keen to do with the people that I work with is where they are embracing that approach is actually to get their buy-in to then sort of trumpet that and to put it out there and to sort of say to people, we're so confident in what we're doing that we're going to open up our approach as a methodology that you can follow and reflect and hope that over time that sort of shifts the dial in the way that, I'm not unique in that, in the way that other people are also doing to try and build a consensus around best practice. But we're a long way away from having a clear regulatory or a codified sort of guidance in the way that, for example, with information security, you do have. So one more.
Yeah, right there, just on the corner. While the mic gets there, I have a hypothetical question. If I have a photo of myself on the internet, can you get it removed for me? I'm joking. Anyway, please have a real question.
Hey, this is another facial recognition one.
Sure.
I was wondering about the use, the commercial application of facial recognition in the private sector. So I'm thinking especially of the company FaceWatch, which are selling the technology to shops, claiming to help prevent shoplifting. What kind of policy is out there in terms of us knowing what shops are using that, so as customers we can make an informed decision where we shop?
So one of the core ways in which compliance is supposed to be assured is through transparency requirements. And if you think about the sort of closest analogy to facial recognition is probably ANPR, so automated number plate recognition. And if you think about if you were going into a car park or an area where that technology was in use, you would expect to see signage explaining to you that that was happening. If you go into the congestion charging zone in London, you'd expect to see signage that sort of says your number plate is going to be captured and processed and compared, with the records at DVLA, and used for charging you. So, in the same way, if you were going into a shop, you would expect certain things about that environment. Firstly, you would expect to be informed in a meaningful way that the technology was in use before you went into the shop, and crucially, before you went into the field of capture of the camera. What we're talking about with some of our clients, and FaceWatch isn't one of my clients, but they're operating in the same space. What we're talking about is, well, how do you actually deliver a meaningful amount of information, given that often there'll be commercial pressure from the retailer to minimise the amount of signage that there is on the exterior of their shop around these issues. So we're looking at things like, I slightly dislike it because of the sort of general attitude these days to QR codes, but something like that, that's a sort of embedded source of information that people can access and then you know, view on their phone, or that they can get in a way that actually it can be delivered in real time. You know, you have to think about, and this is a big issue with something like CCTV or facial recognition. What about partially sighted? What about blind visitors, you know, who aren't going to see that sign? How do you try and make sure that they are appropriately informed before their data is being captured? And you know, you also need to think about whether or not that technology is actually the least intrusive way in which you can achieve that outcome. Sometimes it will be. You know, sometimes something like shoplifting. You know, if you're a big retail chain and you've got a problem with sort of people who are systematically sort of shoplifting from you, sometimes they will be relatively sophisticated. Sometimes they'll use disguises. They'll put on a baseball cap to try and sort of hide from the CCTV. They'll try and change their appearance. They might dye their hair, you know, in order to be able to go back in, even if they've been barred. But if you're using it for other purposes, you know, often these days, you know, people want to use it for sort of customer experience type purposes as well. You know, something that's it's harder to say that that's actually the lowest impact way of doing that compared to, say, a loyalty card, compared to something where the individual actually sort of self-declares that they want to have that level of sort of interaction. So, you know, the signage, the devices themselves should be very prominent. Any of you who've travelled through Heathrow or public spaces where that technology is in operation, you'll have seen the sort of circling LEDs around the outside of the camera lens. And that serves two purposes. Firstly, to sort of draw your attention to it, but secondly, because if you look at it, you get a full-on facial image for the cameras. So it's not entirely sort of disinterested, but it makes you aware, and you can proceed accordingly. But I think a lot of the a lot of the really problematic uses have been in environments where the expectation is not there that you would have that level of surveillance, that level of, so there's been quite a lot about music gigs, people coming along to music gigs and their images being captured and scanned against a watch list of benefit claimants, or people who have debts that are owing to local authorities or outstanding warrants against them. You know, just is that really an appropriate use of the technology? Well, that's where the impact assessment comes in, and you do all the sort of balancing. But all of those things go into that assessment. So when you think about the impact, you think about how aware is the person going to be when they're in that environment that their image is being captured. And ultimately, for commercial organisations, it will be a calculation. How much of our business are we going to drive away because people don't want to be in an environment where facial recognition is being carried out? And you know, if they feel ultimately that that's problematic for them, that's going to cost them more than, say, the shoplifting is costing them, then they may not do it. But they have to take that chance. They can't do it covertly in the hope of having their cake and eating it.
Cool. Let's thank Will once again for the eye-opening presentation.
Thank you.